Hello, everybody, and welcome to today's webinar on Protect, License, Enforce IP strategies for in-house legal teams. My name is Sam Andrews. I'm a business development consultant here at LegalVision. Fortunately, joining us today, we have Rebecca Jones and we have Stephen Drysdale. Before we begin, just a couple quick housekeeping items. Now, we hope you can all remain with us through the entirety of today's webinar. However, bear in mind, you will receive a recording and the slides of this webinar in your email inbox. So if you do have to jump out early, you will receive a recording of today's session. Secondly, can you please submit your questions in the Q&A box? At the end, Rebecca and Stephen will be so kind to answer those questions that you think of throughout the session. Lastly, we are always trying to improve our webinars and our sessions and bring bigger and better webinars to you. At the end of this session, please complete the feedback survey around today's webinar. Now, by joining us today and by registering for today's session, you are eligible for a free consultation with LegalVision to learn about how we can help and assist your in-house team manage your high volume, business as usual, or day-to-day legal tasks. To claim that session, just provide your contact details in the survey, which will pop up at the end of the webinar. Alternatively, of course, our contact details are out there on our website. Feel free to give us a call, shoot us an email, and we can arrange that session for you. Now, I'm going to be handing over to our legal team to take it away from there. Thanks, Rebecca.
Cool. Thanks, Sam. So we'll run you through today's agenda on the next slide. So we've got a few things to cover. We're going to start with, I guess, a bit of an overview of the different types of protection and understanding sort of the lay of the land. There'll be IP we know about, maybe some IP that you're less familiar with. So Rebecca's going to talk you through that. I'll then touch on, I guess, the importance of IP audits and understanding the business and commercial priorities, from I guess, commercial standpoint and also a legal standpoint. And that feeds in nicely into the brand protection strategy and good licensing principles, which Rebecca will speak about. I'll draw on some sort of learned experiences myself around commercial licensing. Prior to LegalVision, I was an in-house counsel for a consumer goods company, dealing with Disney and all sorts of licensors. So I'll be able to share some practical insights there. I'll also touch on some of the boring cross-border tax considerations to consider. And then Rebecca will sort of, towards the end of the session, we'll talk about the importance of active brand enforcement and how to go about it, and what sort of strategies and learnings when dealing with cross-border IP matters you should consider. And then we'll close it off with Q&A. So I'll pass to Rebecca now, and she can sort of walk us through the different types of IP protection that's available. Over to you, Rebecca.
Thanks very much, Stephen. Okay, so first off, let's start with trademarks. Now, trademark registration protects your brand identity, or how consumers recognize the origin of your goods or services. So it might be words, logos, icons, or taglines. It can even be possible to protect some of the less common types of trademarks, such as particular colors, shapes, sounds, or even scents, as long as they act as a badge of origin for your business and the goods and services you're providing. One of the benefits of trademark registration is that it gives you nationwide protection for renewable 10-year periods indefinitely. A key advantage is you get exclusive use rights, and you can prevent confusingly similar trademarks from being used or registered in the same or similar categories of goods and services. Now, it's important to remember that use of a trademark is critical. After 3 years of non-use, a registered trademark may become vulnerable to removal. Next up is copyright. So copyright provides automatic protection for original creative works. Think literary, artistic, dramatic, musical works, films, recordings, and broadcasts. There's no formal registration system for copyright in Australia, and protection arises automatically upon creation. Some critical issues here for in-house counsel are ownership and chain of title, because ownership needs to be established for copyright to be enforced. Although a registration-free system is more accessible, it can also have its challenges. So businesses should maintain detailed records of creation dates and authorship. Employment contracts should clearly vest IP in the company. And if you're engaging with contractors or freelancers, you need explicit assignments because ownership is not automatically vested in the company that engaged those creators. Now, design registration, this protects the visual appearance of a product. So think the shape, the configuration, perhaps a distinctive pattern or ornamentation of your products. Design registration can be a really valuable form of protection for businesses where aesthetics drive consumer choice. It's important to know that you must file before public disclosure, although there is a grace period that can apply in certain circumstances. So you'll want to coordinate your design applications with your product launches. File before any public unveiling, and that would include social media or trade shows. And design registration lasts for up to 10 years. Now, next up is patents. Now, patents protect inventions, so new and inventive solutions to technical problems. A standard patent can be registered for a 20-year term, and there's quite a few strict requirements. So the invention must be novel, it must be inventive, and it must be useful. Again, non-disclosure is critical for patent protection. Now, patents can be expensive and time-consuming. It can take several years to get through examination. So it's really a strategic question for the business. Does the patent protection justify the cost? You'll want to consider the length of the product's life cycle, the ease of competitors reverse engineering the product, potentially alternative IP protections that might be more affordable or accessible. And all of this will be considered in the context of the competitive landscape in which you're operating. Also remember that patent applications generally become public after 18 months. So there's a trade-off essentially in that in exchange for the protection that you're granted for a certain period of time, you're disclosing details of your invention to others. Okay, finally, a couple of non-statutory IP protection mechanisms. Now, trade secrets. This is information that can be protected as a trade secret, is generally confidential business information that provides the business with a competitive edge. So this might include things like formulas, processes, customer lists, potentially pricing strategies or business plans. There's no time limit on trade secrets, so they don't expire as such, and there's no registration requirement. But it is very important to note that trade secrets require active protection. So this is done through confidentiality agreements, restricting access to a need-to-know basis, physical and digital security measures, and ensuring that relevant documents are appropriately marked as confidential. Now, the challenge to bear in mind with this form of protection, if the confidentiality is breached and the information becomes public, protection can be lost forever. And last but not least, contractual mechanisms for protecting IP. Now, a well-drafted contract or IP clause provides flexible, tailored protections beyond statutory rights. Key mechanisms here include non-disclosure agreements, non-compete clauses, restraint of trade clauses, IP assignments and licenses, and joint development agreements. To ensure they are enforceable, you'll want to make sure they are reasonable in scope, duration, and geographic reach. All right, now I'll pass back to you, Stephen. Stephen's going to take us through the importance of doing an IP audit and understanding the business and commercial priorities.
Thanks, Rebecca. Yes, this is a really critical point for a lot of businesses when you've gone through that process of kind of what Rebecca's already outlined. What are my different areas where I can protect? What are the types of IP protection that are available to me? And you've gone ahead and you've obtained that. That's all in well. You've got it. You've got that first stage, but then there's this ongoing sort of life cycle of management when it comes to your IP portfolio. Now, some businesses will have a very small IP portfolio. They might just have a trademark. Some might have much bigger portfolio of registered rights. Some might not even have a portfolio at all. They've not actually considered or kept up with what is actually happening in the business. And so for in-house counsel especially, but for any business owner really, is what is going on in the business and what is the kind of commercial priority. So there's a few different ways that we can do it. So when I was in-house, there were sort of a few different ways that I approached this. I had formal audits. We had a patent portfolio of over sort of 200 rights and over 1,000 trademarks. So there was a lot to manage, and there were always conversations happening between marketing teams and sales teams and product teams about brand strategy and new brands and sub brands and everything you could in between. So it's really hard to sort of always have your finger on the pulse, but some of the ways that I found helpful were formal audits. So sending out maybe either quarterly or 6 monthly, sitting down with key stakeholders, head of product, head of sales, head of marketing, and saying, this is what we have. This is the lay of the land in terms of our IP portfolio. Is this still relevant? Are we still selling into these markets? Where are we looking to sell into next? Is this a new market that we're launching into that we're not, yet aware of, or I'm not yet aware of, I should say? And have we launched new brands, or we're redesigning packaging even? Just trying to understand those things. But there was also, I think, a really helpful approach in sort of what I call real-time monitoring, which is sort of lurking in meetings and finding out what's actually happening in real time. So going to product meetings, going to marketing meetings from time to time, just to get a sense of what's happening, what's shifting. Sales meetings in particular, or sales stand-ups can be really useful in just understanding what competitors are doing and where you might need to actually preempt competitor activity where it might be, kind of close to the line and infringing on your valuable brand and your other IP. So that's a really important thing as well. And then some of the other strategic insights that, typically helpful and that I found helpful were, sales data in terms of, someone might tell you that, this is a really big market, but then you look at the data and you go, well, this is the 30th, not even the top 30 market. So do I really want to be justifying an annual cost here to maintain this patent, or to file a trademark here and go through that process? That's the sort of thing that can be really useful. And that helps to inform, sort of a global IP strategy. And patents do require particular focus. They have a sort of annual maintenance cost that can really rack up quite quickly, particularly where you've gone for sort of global approach. Not only have you spent a lot of money to get those patents in the first place, so you don't just want to get rid of them, willy-nilly, but equally you need to have a measured approach and say, well, do I really want to pay a few $100s a year to that local IP office and probably the local lawyer in that market that's helping you do that, if it's a market that's not actually a priority for the business? So yeah, really, really key to sort of have a framework in place for these IP audits. But I'll pass back to Rebecca now to speak about brand protection.
Cool, thanks, Stephen. Okay, so the first thing I always say is apply to register your trademark as soon as possible. Secure that priority date, get in there potentially before other people that might be looking to file a similar trademark, and so get that underway ASAP. Before using a new trademark, I always recommend conducting a search to avoid inadvertently infringing the rights of a third party. So in those early stages, when you're tossing around ideas for new trademarks, new product names, carrying out that search in that early stage can be really helpful in terms of making sure that that trademark will ultimately be available for the business to use and register. You want to look at protecting different elements or layers of your branding for the best protection. So a good comprehensive trademark portfolio generally includes trademark registrations for different elements of the branding. So there might be word marks, logos, taglines, all the different kind of elements that operate as badges of origin for your business. In terms of the scope of the coverage of your trademark protection, think about what the business is doing now, but also areas that you're planning to enter in the future, whether that be new product categories or new overseas markets. If you are filing internationally, make use of the priority periods. So generally, if you file internationally within 6 months of filing your Australian application, you can claim the earlier filing date in your overseas protection as well. All right, next, let's move on to license agreements. Now, these are a great tool to enable IP owners to commercialize their IP, say, at a greater scale than perhaps they could themselves, by granting specific licenses to allow third parties to commercialize their IP. The core elements of a good license agreement. You'll want to make sure you've got crystal clear definitions. So cover off what IP is being licensed, for what purpose it can be used. Is it limited to particular products or services? Define the territory and the exclusivity level. Is it an exclusive or a non-exclusive license? Can the owner of the IP also commercialize it concurrently with the licensee? Can it be sub-licensed? And it's important to precisely define the scope at the outset to avoid disputes down the track. Now, in the grant of rights provisions, you'll need to specify exactly what the licensee can and cannot do. So think about addressing things like manufacturing, selling, importing, sub-licensing, modifications, and derivative works. You might include field of use restrictions, territorial restrictions, and address the transferability of the license as well. It's important to remember for trademark licenses that the owner must maintain quality control to preserve their rights in the trademark. When it comes to financial terms, there's a few different structure options. So you might have upfront fees, ongoing royalties, minimum guarantees, and milestone payments. The agreement might specify the royalty base, the rate, the payment frequency, currency, exchange rates, and you'll also want to include robust audit rights. Now, like I mentioned, quality control is really important for brand protection, particularly in a licensing situation. So it's legally required for trademark licenses to avoid diminishing the owner's rights. You'll want to include quality standards requirements, inspection rights, sample approval, and termination rights for quality failures. You'll also want to stipulate that the licensee uses the trademark correctly as per your business's brand guidelines. So you might prohibit alterations to the trademark without approval. Now, onto the next slide, we'll be looking at term and termination. So the license will specify the initial term and renewal options. You'll include termination rights. This might be for material breach, insolvency, non-payment, or potentially performance failures. It's useful to include detailed wind down provisions. So what happens to existing inventory? Are there phase out periods? Covering everything to do with the IP use cessation and the return of confidential information as well. You will want to address IP ownership and improvements. So you'll confirm that the licensor retains the ownership of the licensed IP. You'll want to address ownership of improvements and derivative works and include assignment provisions or grant back licenses to the licensor as appropriate. And finally on this, we'll look at indemnities and warranties. So the licensor typically warrants ownership and the right to grant the license, but be cautious about non-infringement warranties and consider the amount of risk the business is comfortable taking on in the commercial context of the agreement. Now I'll pass over to Stephen to go into a bit more detail about what in-house counsel need to know about commercial licensing strategies.
Thanks, Rebecca. Yeah, so this is quite important. So there's, as Rebecca's touched on, the sort of legal aspects to these arrangements, getting those contracts right is obviously fundamental, but there's a really key role for, in-house lawyers and, I think anyone really involved in business to be across from just a more commercial standpoint is getting involved early. It's really important to, especially, if you're in the position where you're kind of seeing everything that's going on, you're seeing all the deals, you have a really valuable insight into what is, I guess, acceptable or not acceptable, or, what past trends have been in terms of what you promised to, either other licensees or if you're a licensee yourself to other licensors. So getting involved early with deal memos and term sheets can be a really helpful way of doing that. Confirming, does this make sense, for this particular product, for example. We've, traditionally done percentage royalties. Why are we now doing, fixed or flat rates? Stuff like that you can kind of add value there is really important. And also sort of stop things before they kind of get too far down the garden path to kind of unwind. If you're a licensor and you're the one sort of giving away rights to your IP for someone else to commercialize, then it's really important that you have things like minimum guarantees, which is essentially, the minimum amount of royalties that you're expected to receive under the agreement. Otherwise, you can terminate, or in some cases, what happens is there'll be a shortfall payment required. So they'll say, if you don't meet the $100,000 minimum guarantee, then you need to basically pay a lump sum to get to that point as a contractual requirement. Very common in sort of US licensing agreements, but you'll see it, a lot more, I think, globally as a result. And you've also found and I've also found in my experience, you'll see a lot more advances, so royalty advances being requested. So licensors asking for their licensees to actually pay a lump sum at the start of the contract, which is then applied as a credit on future royalty earnings. And that just helps with, I guess, cash flow, for the licensor and certainty that there's investment by the licensee. If you're the licensee, then on the flip side, you want to make sure that those minimum guarantees are feasible. We sometimes will see multi-year guarantees. So year one, you pay this much, year two, you pay this much, and so on and so forth. Typically, if you're in, say, a product industry, that first year is where sales really boom. It's new to market, it's fun, it's fresh, everyone wants it. And then you get to year two, and then sometimes sales do drop off. So having to think about, well, what is the sales trends for these types of products or these types of services? Do we need to kind of adjust the minimum guarantee to reflect that, have a high minimum guarantee in year one that we know we can earn out versus a lower one in year two? Because what most licensors will have in their agreements is that you can't, I think they call it cross-collateralize. So you can't take royalties from year one and apply them towards a guarantee in year two, and vice versa. You can't backfill either if you fell short in year one. So it's really important to get that right. In terms of marketing commitments, so if you're a licensor, you probably want your licensees to dedicate, money into marketing, making sure the sort of the license arrangement is successful, that it's known to the market, that there are sales and therefore there are royalties. So you might impose, say, a minimum marketing spend, or you might have a common marketing fund where you're asking your licensees to actually pay either a percentage of sales or a lump sum into kind of a slush fund that you can spend as the brand owner or the IP owner on your own marketing activities. Now, if you're the licensee, it's usually better for you to have a percentage just committed to your own marketing spend so that you can actually choose how you want to spend those dollars. Common marketing funds are great for licensors, not really that great for licensees, because ultimately that money isn't actually committed to be spent on your licensing arrangement. It's spent on the general, building of goodwill and reputation of the IP generally. So, that might be dedicated towards your licensing agreement, but more often than not, it's just a general cash grab, basically. So have a think about, is that something that you want to do? And is that the sort of, way you want to do it? And maybe you negotiate that out and have a bigger commitment to your own marketing spend, for example. Usually around 1 to 3% would be kind of the norm in most sectors, so that you don't overcommit yourself either. But yeah, that's sort of the kind of the key things to understand about commercial licensing. On the next slide, I think I've got 2 points on tax, and I'll keep this brief because I know this isn't usually everyone's sort of favorite point, but 2 things to really think about from a tax perspective when we talk about these licensing arrangements, mainly when we're dealing with 2 parties that are in different jurisdictions. So you might be here as a licensee in Australia and your licensors in the US. There's this concept of withholding taxes, and essentially that's a tax on the US license or the foreign licensor, but they're not in Australia. The ATO can't impose a direct obligation on them to pay their tax. So what they do is they say, well, if you're the recipient, you're the licensee, when you make a royalty payment to an offshore licensor, you actually have to withhold their tax on their behalf and pay it to the ATO on their behalf. Now, you'll see a lot of times in agreements that they'll say that you can do that and that's fine, or what they'll say is, yep, you can do that, but you actually have to pay us the withholding tax as a separate amount. So say, for example, you had a $100 royalty and it was a $10 withholding tax. The licensor will actually want you to pay $110 so that they're not out of pocket, which isn't really fair, particularly because they can often then claim a foreign tax credit. So they can go to their local tax office and say, I pay $10 tax in Australia, give me a $10 tax credit. And so essentially they're double dipping. You're paying their tax for them and they're getting a tax credit. So the fair and sort of equitable way to do it is you'll take the money out of the royalty payment, you'll pay it to the ATO, you'll get a tax receipt or proof of filing, and you'll give that to them so they could claim their own foreign tax credit. And there are sometimes international treaties that sort of reduce how much tax has to be paid. So it's often commercially beneficial to kind of go down that path and look, act in good faith and help them obtain those reduced rates. The other one that comes up is transfer pricing. This is where we've got this is between related companies that are in different countries. So we can't just charge things back at cost. There needs to be an arm's length sort of margin or arm's length rate. So if we're talking about intercompany service agreements, or what's quite common is intercompany license agreements, particularly say in software, you might have an agreement between your IP company in one country that allows your trading company in another country to resell the software locally. You need to speak to basically a transfer pricing specialist to work out what is the market rate at arm's length for that amount. If you get that wrong, then the ATO might have questions. So that's just a really important one to be across. But that's all I had on tax. So I'll stop it there, and then I'll pass to Rebecca to speak about brand enforcement.
Cool. Thanks, Stephen. Okay, so it's really important to think about brand enforcement as a kind of active rather than reactive part of the business. So failure to enforce the brand may lead to genericism, which can be fatal for a trademark registration. It can also lead to acquiescence, brand dilution, and it can be a market signal of weakness as well. Courts may consider enforcement history when considering appropriate damages and relief, and a strong enforcement track record really enhances settlement credibility as well for a business. Ideally, you'll have a systematic monitoring program in place. So keep an eye on online marketplaces, social media, internet and marketplace search engines, domain name registrations and trademark applications. And a tip here is I think it's a good idea to set up Google alerts for your key brands. And that way, if anyone makes unauthorized use of those, you'll get notified. It will land directly in your inbox, which can be very useful. On to the next slide. Thank you, Sam. So you want to consider your proportionate response framework to any enforcement issues. So you'll assess your enforcement priorities based on the commercial impact, so the financial or market effect of the infringement. You'll also want to consider the risk of brand confusion amongst consumers, the risk of reputational harm or damage to your business's goodwill. You'll want to assess the infringer profile and decide strategically whether pursuing this aggressively is worthwhile, particularly considering the potential precedent value as well. Now, in your enforcement toolkit, you can consider things like informal communications with an unauthorized user, escalating to formal cease and desist letters. You can file platform takedowns. You can record customs notices to stop counterfeit or infringing goods at the border. And then also, you can consider coexistence arrangements, settlement agreements, and then obviously litigation if required. Now, let's talk about some approaches to brand enforcement. So first of all, online marketplaces. The major platforms have pretty good IP infringement reporting systems. You can register your trademarks in brand registry programs such as Amazon, which can really assist in quick takedowns of unauthorized use of your IP. Most platforms will respond within days for clear cases of infringement. On the social media side of things, some common issues that we encounter on social media are fake accounts, unauthorized logo use, or the promotion of counterfeit products. You can use platform-specific reporting mechanisms, so these can address trademark infringement, copyright infringement, and impersonation accounts. For domain name disputes, now, this is a great tool when an unauthorized domain name is involved. Domain name dispute processes are much faster and cheaper than litigation, taking around 2 to 3 months, usually a few $1,000s, so can be a good option. It's an essential requirement to prove that the domain was registered or used in bad faith. Another tool is customs enforcement. So you can record your IP rights, such as registered trademarks or designs, with the Australian Border Force. And the Border Force can then detain suspected counterfeits on behalf of the business. Finally, litigation strategy. Now, given the resources required to pursue litigation, generally you'll use this strategically when there are substantial commercial interests involved. Perhaps you've tried some other methods of resolving it and they have failed. Perhaps you need to seek injunctive relief, want to establish a precedent, or to send a deterrent message. Before proceeding with litigation, it's always useful to conduct a cost-benefit analysis, take into account the prospects of success, the realistic relief that you might be able to obtain, and the defendant's ability to pay or comply with any orders. Of course, you'll also want to consider participating in alternative dispute resolution before trial as well. I'll pass back to you, Stephen, to take us through cross-border strategies and learnings.
Cool. Thanks, Rebecca. Yeah, in terms of, and just to add to something that Rebecca mentioned before about the litigation piece, when you're making that call too on, what is the best approach? It kind of also depends on the profile of your infringer. So, do they have the money to pay is one thing. And also, what's the scale? Litigation is really good for an infringer that's large and doing widespread damage, but probably not so good for, say, drop shippers from overseas, where, online takedowns and marketplace procedures will be much better suited. Now, in terms of these cross-border strategies and sort of, I guess, key takeaways, we really want to focus on priority markets. So IP management and the IP life cycle isn't cheap, or it isn't free, and it does come at a cost. And so we want to be strategic about, what are we maintaining, why are we maintaining it, and how are we, I guess, enforcing it. So part of that will be, what are the jurisdictions that matter most? Is it where, usually it's obviously where you're selling and where you're making money is obviously a big one, but also sometimes where you are, if you're in, say, product, where you're manufacturing can also be important. Now, a lot of people manufacture in jurisdictions where maybe the legal systems are quite different to Australia. They may be, they may not be common law, they may be, a different way of doing things. And also maybe, the court systems aren't as aggressive, or maybe you don't have as much recourse there as you might in somewhere like Australia. But often having that IP can still be useful in putting people on notice, makes people, or say factories, for example, less keen to make counterfeit or imitation product, based on my experience, even if you're not using it for litigation purposes. So really honing into those priority markets is key. You want to match your enforcement to outcome. As Rebecca said, you want to make sure that you're spending time and money in the right place. So if someone is a big infringer and you've tried everything else, litigation might be the best option. But really it's working out, where are the pain points and what is going to be the best tool for the job. Making sure that, we are doing things strategically, and your time is precious. We don't want to be chasing down rabbit holes where we're not actually going to get an outcome. And if we can get, maybe we can't get a nice clean settlement agreement, but if we can kind of scare someone to, no longer infringing, that's probably still a good win for the business. Implementing those systems for regular audits and reviews, as we spoke about, is really key. Making sure that we have our finger on the pulse, that we know what's going on, and then making sure that what we are maintaining is fit for purpose and remains fit for purpose. And if you're a licensor, making sure you have processes in place for active licensing monitoring. So having, those quality control procedures that Rebecca mentioned, having those KPIs like minimum guarantees, having requirements to, commercialize in particular markets, or you're kind of like a use it or lose it system. If you don't get into a market by a particular launch date, then you lose that market from your license scope. So making sure that people are doing what they're meant to from a licensing standpoint, and clear audit rights. It's pretty common for your US licensors, particularly Disney's a notorious one for actually going into your business and auditing everything from top to bottom. I say it's their additional revenue stream. They basically will go in, they'll audit, they'll work out for non-compliance, and then hit you with another bill. So making sure that you understand what's in the agreements if you're a licensee, what's in your agreements with licensors, and vice versa. Making sure if you're a licensor, that you have these clear audit rights and these clear mechanisms to kind of make sure that you're getting paid what you're meant to be paid, that your IP is not being misused without your knowledge or stolen into places where maybe you don't have the protection or you're not planning to commercialize, is important as well. Now, I think that's all that we had in terms of content today. I think I'll pass back to Sam now to do a wrap up, and then obviously move to Q&A. So please start putting through your questions to the Q&A box as well. I've got some pre-submitted ones too to talk through, I believe.
Okay, everybody. Now that concludes the main part of today's webinar, as Stephen mentioned, on Protect, License, Enforce, IP strategies for in-house legal teams. I want to take a moment, Stephen and Rebecca, you've earned yourself a glass of water, that's for sure. Thanks for taking us through that today. We really appreciate it. Now, here at LegalVision, we're always trying to get as much information out there as possible. We have a publication here today for a free download. So certainly feel free to jump on that and grab that download, applicable to today's session, of course, around trademark essentials. Join us for our next event. So coming up next, we have on the 4th of December, 11 a.m., managing corporate immigration risks and what in-house counsel needs to know. So certainly feel free to register. Come join us again. We'd love to welcome you back. Now, we're going to answer your questions very shortly, as Stephen mentioned. While you send those questions through, and please do send through a few questions, just a quick word on LegalVision's desk extension model. I touched on this briefly earlier, but having spoken with many in-house counsel, We know you're under pressure to balance strategic input at the executive level, also with a heavy load of day-to-day matters or BAU matters, all within tight budgets and a tough labour market. Our desk extension service helps by handling business as usual, day-to-day legal needs, boosting your team's capacity and freeing you up to focus on more critical and strategic priorities. So our lawyers embedded themselves in your business, so they work as a true extension of your legal function. Now, to learn more, as I mentioned earlier, certainly feel free to leave your details at the end of the survey. That's a way for us to get in touch. Our contact details all over our website. Give us a call, shoot us an email, and we'll be able to take you through our DE or desk extension model. Now, I'm going to be handing back to our hosts to answer any of those questions that you so kindly put out. While they go through those questions, you are going to see a poll question pop up on your screen. We'd really appreciate it if you could please answer it to give us more insight. Back to you, team.
Cool, thanks, Sam. I'll start the Q&A. So we had a question about business structuring and corporate structuring from an IP standpoint. The question was around, having an operating company versus a separate parent or holding company, and what's the sort of, benefit and a bit more information about that. So the reason typically we recommend separating these out is really about risk and asset protection. So if you can imagine, your IP is obviously your most valuable asset. That's why we're here today on this webinar. And you want to make sure that that IP is safe from any sort of, claim risk. Now, common claim risks are things like contractual claims, regulator claims, employee claims, for example, and anything sort of under, statutory claims, maybe under consumer law is another common one. So what we recommend to kind of, resolve that or de-risk that is you have your subsidiary that will do all the day-to-day stuff, hire your employees, sign in contracts with your customers, with your suppliers and the like. And then it is owned by a holding company that basically just holds the IP, and usually your investors invest in that entity because that is where the value is. So that's just helpful to deal with expansion, because then you can just set up a number of subsidiaries under that holdco, and then have internal licensing arrangements and service arrangements between them. So it makes it really scalable for investment, and also sometimes it just helps to, if you ever needed to restructure further, it's a lot cleaner to sort of move things out of an empty company than it is to sort of try and move things when you've also got employees and the like and other contracts on foot. So just makes life a bit easier. Rebecca, I think you had a question about trademarks. Did you want to?
Yes. So we had a really good question. What should be considered in determining what we do and don't trademark? For example, major brands versus products, etc. And this is a really good one. And depending on the business, you may have new product categories coming up all the time. It's a limited time thing. You don't know, what the market is going to be like, whether it's going to end up being long-standing. So it really is a balance between the cost of protecting that and the benefit of having it protected. I'll often say, obviously the best protection is to have everything protected, but that sometimes isn't viable. So it's useful to look at both the benefits and the risk. And from the risk perspective, I think of, if you don't protect this trademark and you go and use it in a particular market, for example, over in the US, what is the risk there? How big are your sales going to be? If you were to inadvertently infringe a third-party trademark, how much of an issue is this going to be for you if you don't have that protection to rely on? So that's a good way of looking at it. And as well, from the benefits perspective, if you go into this market and, it's a market where the brand is popular and someone else, copies your brand or encroaches on your rights, how much damage will that do to your business? Is this a really key player in your range of products or services, or is it something that isn't crucial to the success of your business and might not be worth it? The other thing to look at is how committed you are to the trademark. If it's something that you have invested significantly in, you've printed a bunch of you've had a bunch of things manufactured that bear the trademark, that type of thing, something that you couldn't easily pivot away from if you needed to, that can often help to justify the expense of protecting it as well. Back to you, Stephen, if you want to answer another question.
Yeah, I had I guess there's two questions that are kind of related, so I'll deal with them together. So the first part of the first question was around AI tools and IP and how that sort of works in practice. Now, it's really important to note that a lot of the kind of publicly available AI models typically, might use what you put in to train their data sets and to improve their language models. So to the extent that you're putting in anything that's proprietary or confidential or really critical value to the business, you kind of want to be sure that you're using either, say, some sort of paid enterprise version where they aren't doing that and it still remains your information. You want to really carefully review those terms, or sometimes businesses will actually build their own internal, they'll build, but they'll have it hosted on their own servers to kind of keep things within in-house and to keep it safe from inadvertent disclosure, particularly if they're using it for personal information. So if they're putting client details, customer lists and the like, where they might doing so in a publicly available model might constitute a data breach. So we want to make sure that that's clear. And then I guess the other part of the second question was around, kind of related to that, when we're talking about licensing and we're talking about, different inputs. So maybe it's IP you've created yourself, maybe it's something that you've licensed from someone else and you need to pass it on. How does that sort of work? Typically, when we think of licensing, we think of sort of different buckets. So there's what we call sort of our materials. So what we're bringing to the table. There's your materials, which is what the other person's bringing to the table in terms of pre-existing IP. Sometimes it's just under that common umbrella. Then we've got the two other buckets, which are the respective improvements or the derivatives of existing IP. And then we've got this nice last bucket in the middle, which is the new stuff. Now, your pre-existing stuff might include stuff you've created yourself and might include things that you're allowed to sub-license through, like maybe it's software, maybe it's something that someone else has created that you're licensing, but they've said clearly in that grant of license that you can on-license that. What's really key is the new stuff. What are we doing with the stuff that's new and created? Who owns it? If you're a developer, for example, you probably don't want to give it away straight away. Maybe you only want to give ownership when you get paid. So thinking about those sort of things and how that new material will be dealt with is actually critical. But yeah, there's nothing wrong with sort of licensing through IP that you've got from someone else, provided that you actually have the right to do that. I'll pass back to you, Rebecca. I think you had another question.
Thanks, Stephen. Now, someone asked us to talk a little bit about other forms of trademarks, so other than words or logos. So I touched on briefly earlier, there are other, we call them non-traditional forms of trademarks. So it is possible to register, for example, a sound. I think the Nokia ringtone is a registered trademark last time I checked. Perhaps even McDonald's little ba-da-ba-ba-ba jingle. So those are two that come to mind on that. You can also protect colours in some circumstances. So I believe Cadbury has the colour purple registered as a trademark in respect of chocolate or confectionery products. Those ones can be quite hard to achieve. I know, for example, that BP had tried to register the colour green in respect of their service stations and put on a lot of evidence of acquired distinctiveness, and that still wasn't enough. So the threshold is very high, considering it is quite a broad monopoly that you're getting in those types of non-traditional marks, particularly when it comes to colours, for you to be able to prevent third parties from identifying their products in a similar way is quite a broad right, and therefore, understandably difficult to achieve. But when you get into kind of combination of colours or three different colours that aren't common to use in that industry and things like that, it can be more achievable. It's also possible to protect scents as trademarks. I think those are probably one of the least common in Australia, at least. But yeah, it is technically possible. Do we have time for one more question, Stephen?
I think we can fit one more in.
Do you want to?
Yeah, I'm happy to take it. So we had a question come in about unregistered trademark rights and I guess prior use. So one really key thing about, I guess, trademarks and brands generally is you do often, and in places like Australia, New Zealand, common law jurisdictions, where you can still have rights even if you haven't filed an application and had your trademark registered with the government office. So we call these sort of common law rights, and they do exist and they can be enforced. they involve a little bit more steps to actually litigate, for example. So you have to actually prove that you've got established goodwill in that particular market. And so the benefit of a trademark registration is it kind of shortcuts that process. By having the registration, you have there's a presumption that you have goodwill recognised across the market, across all of Australia, not just in, say, Sydney or Melbourne or Brisbane, where your business might operate. So that's the kind of the key benefit. Now, if someone in your local market is using competing names, so you've got unregistered rights that you've accrued because everyone knows you've been around for a while, and a new competitor enters the market infringing on your trademark or your unregistered trademark, then you may have a recourse there. But if you're on the East Coast and they're on the West Coast and you don't have anything to do with the West Coast, that might be a little bit harder to sort of justify or to prove. Whereas if you had a registered trademark, you could, you would have that presumption nationwide, even if you weren't necessarily in WA, for example. So I hope that answers the question. I don't know if you want to add anything there, Beck, but conscious that we're sort of running out of time, so we might have to wrap up.
I'll just add quickly, a really good benefit there is that evidentiary burden. If you've only got the reputation and not the registered trademark, it's not a matter of just, pulling out your registration certificate and saying, you're infringing my registered rights. It's first establishing you have that reputation, which can be a very onerous and therefore expensive process. That is all that we have time for today. Sorry if we haven't answered your question. Please submit your details in the survey at the end for assistance with questions that we didn't answer, or to learn more about how our membership can help you. And while this is a free webinar, we really value your feedback. So please complete the 30-second survey at the end.
Thank you, everyone.
Thanks for joining us.
Thank you.